Hi friends, welcome to the channel. This is your Govindraj. Thank you very much for watching my previous videos and also sharing it in your network. And also today this channel has got more than 250 videos, and this also has got a subscription channel where you can become a member and get to access more and more technical videos explained precisely the legal provisions and the judicial trend. Thank you very much for that. And today I'm going to talk about one important topic, whether industries in Karnataka Industrial Areas Development Board area, KDB area, whether they have to pay the property tax for the land and buildings. Normally when you have a property, either it is a plain land or a building, so you are required to pay the property tax to the local authority. But in Karnataka, whether if your industry is available in KIADB industrial area, whether you have to pay the tax to the municipality or to the Gram Panchayat is the topic of subject which we are going to talk about today. So in order to understand this topic, we have to know there are certain key provisions of Karnataka Industrial Areas Development Act 1966, and also we have to look into the provisions of Karnataka Municipalities Act 1964, and for the Panchayats, which is Karnataka Gram Swaraj and Panchayath Act 1993. Originally this is Karnataka Panchayath Act. It was renamed as Karnataka Gram Swaraj and Panchayath Act 1993, and we are going to see whether there is any judicial trend is available on this topic. Now if you look at the Karnataka Industrial Areas Development Act and the Karnataka Industrial Areas Development Board, it is actually vested with power and authority for planning, development and maintenance of industrial areas. So there are industries who are beyond KIADB areas, and there are industries which are developed industrial areas by KIADB and other associated bodies, and these industrial area will continue to be under the jurisdiction of this KIADB until such area is specifically removed from the jurisdiction of the board. And if you look at this KIAD Act section 37, the provision is very clear: until a specific notification is issued to remove the jurisdiction of the KIADB, then that is going to be there only in the jurisdiction of KIADB, and no other authority will have any power for the maintenance and development and also the planning of these activities. Therefore, what I am telling you is if there is an industry in KIADB, the municipality or the panchayat have no authority on the matters of development and maintenance and even the levy of tax. Now let's look into another section which is very important, which is in KIAD Act, Karnataka Industrial Areas Development Act, which is section 47. This gives an overriding effect to KIADB and under authority under the KIAD to the overriding effect on other statutes, because once this provision is included, the other statutory authorities or other provisions of the other acts, including the Municipalities Act and the Gram Swaraj Act, are not going to have any impact on the provisions which are available in KIAD Act. Now let's look into about these municipalities and panchayats. See, these are the authorities where any land and building is there in their notified areas. They collect various taxes, including property tax, for the development and maintenance of the area under their jurisdiction. Mainly, if you look at Karnataka Municipalities Act section 94, section 94 of Karnataka Municipalities Act 1964 allows levy of property tax on land and buildings in their area. Similarly, for panchayats, there is another statute called Karnataka Gram Swaraj and Panchayath Act 1993. You have to look into section 199, which also is a charging section which allows levy of property tax on land and buildings in their areas. Now, another schedule which is appended to the statute, Schedule 4, lists certain items and rates for taxation. So very importantly, you have to see entry 3 in the Schedule 4, which specifically requires notification from the government for levy of tax on land and buildings in KIADB, Special Economic Zone and other industrial area or zone. So this is the schedule which talks about the tax rate on different buildings, whether it's residential or commercial or industries. So these are the tax rates are going to be given. But in item 3, there is a specific provision is available in order to levy the tax on industrial areas where the industries are situated in KIADB or other SEZs. Then there should be a specific notification. So therefore, as long as there is no such notification, removing the jurisdiction of KIADB and allowing the panchayats to levy tax, they cannot levy tax. So therefore, there has to be a notification in case of industries in KIADB area for panchayats or the municipalities to levy the tax on industries. So as long as there is no notification with regard to this, then these authorities have no business to levy the tax on industries. So these are the actual provisions which are available in KIAD Act and the Gram Swaraj, Karnataka Gram Swaraj and Panchayath Raj Act 1993. These provisions are very clear. Now recently this matter has been taken before the High Court, Honourable High Court of Karnataka, because though these provisions are available, though the jurisdiction is not removed from the KIADB, the Panchayats and municipalities have continued to levy the tax on employers which are situated in industrial areas, KIADB industrial area zones. And some of employers also have paid tax, and of course some of the employers are aware of these provisions and they went to the Honourable High Court of Karnataka, especially in the case of Kalpataru Breweries versus State of Karnataka, and there are many other employers also have joined this writ petition. And considering the provisions of these statutes of Karnataka Industrial Areas Development Act and Panchayath Acts, the Honourable Court held that the jurisdiction of KIADB remains intact and exclusive until a notification is issued to remove such jurisdiction. And this power of panchayats to impose tax on properties within KIADB or other notified industrial areas under Schedule 4 is not absolute or automatic, rather it is subject to notification, because as I have told you, the item 3 in Schedule 4 very clearly says that there has to be a notification with regard to industries for levying of tax. So the court looked into the KIAD Act and also Panchayath Acts, and it interpreted harmoniously so that a justifiable meaning is given. So therefore, any such exercises in the hands of Panchayat and also the municipalities will be ultra vires and without authority of law, because as long as they do not have any authority, they cannot levy tax on the industries which are situated in industrial areas development board areas, and also the SEZs and the areas which are developed by other authorities also. So if you look at Article 265 of the Constitution, it actually mandates that no tax shall be levied or collected except by authority of law. Therefore, what I am saying, friends, is you have to ensure that the area where your industry is situated is denotified from the jurisdiction of KIADB before you decide to pay your tax to the panchayats. So therefore, if you are in KIADB area, ensure that or ask these questions to KIADB whether there is any such denotification is available, or even to the panchayats whether there is any such denotification is available. If there is no such denotification available, you are not required to pay tax to the panchayats. So that is what is the interpretation of this statute recently by the Honourable High Court of Karnataka. Thank you very much, friends. I am sure this piece of information has given more information on this topic. I'm going to come up with more and more videos in the future. And in case you would like to become the member of membership channel for highly technical videos, I'm going to give you the link in the description box where you can access to that and become a member and watch highly technical videos in the channel, friends. Until then, see you soon, friends. I will come back with new video, friends.